Smith-Basildon.
My Lords, I beg leave to ask the question standing in my name on the order paper.
My Lords, I understand the importance of ensuring that children's privacy is respected, and there are safeguards in place to protect this. The Government has introduced a new system of independent press self-regulation, and there are remedies available under civil law. The Government is committed to tackling the production and distribution of indecent images of children, and criminal offences are available in such cases.
My Lords, I think we have to be clear about what the Children's Privacy Campaign Protect is asking the Government to consider. Because surely it's entirely reasonable and responsible that when identifying an individual child in a published photograph, there should be either consent or good reason. And if not, the image should be pixelated or blurred. The Noble Lord the Minister spoke about self-regulation. If that was working, why did Hannah Weller have to go to court? And why did the judge say that the law needs clarification? Would the Minister agree to meet with Protect to understand parents' concerns and consider how children's privacy can be protected?
My Lords, first of all, can I thank the Noble Baroness for her question, and in order say, firstly, that my right honourable friend, the Deputy Prime Minister, has met with campaigners. I would be very happy to facilitate further meetings if that would be helpful. In respect of the particular case which she refers to, as I understand, it's an ongoing legal matter. She'll understand if I don't comment on the specifics. But when it comes to the matter which is at hand about self-regulation, it's very important that the Editor's Code actually stipulates that where a child is under the age of 16, then consent should be sought. And that is something which should happen under that code and under self-regulation, and where that doesn't happen, then there is redress through the civil courts.
My Lords, clearly society's moral duty is to protect all children. The Ofcom Broadcasting Code, Section 8, does so, and it's very specific about the privacy and protection of children, and all broadcasters carry out these rules responsibly. So can I ask my noble friend, the Minister, what can be done to ensure that similar rules, which refer more specifically to this type of photography, are included in the Print Media Code of Practice and adhered to in order to protect children from unwanted exposure and potential harm?
I'm grateful to Noble Friend for that question, and indeed it follows on that the Ofcom regulation which is there in 1.8, which talks about the protection of children, is something which is actually mirrored in the Code of Ethics under the self-regulatory organisation. What we clearly need to do is to ensure that that is working and that people are protected. At the same time, there needs to be a balance between, on the one hand, large crowd scenes where children might be involved, or a premiere of a movie where a child star may be putting themselves in the public domain, and those where privacy is involved. That's the fine balance which needs to be reached.
My Lord, will the Noble Lord accept that those who have disabilities are still having huge difficulties in coming forward and reporting child sexual abuse or needing protection? Will the Noble Lord the Minister assure the House that at all aspects of dealing with these matters, whether with the media, whether in social justice arena, or simply the law, that he will take on board the particular specific needs of those with disabilities, and in particular with autism?
And in relation to disabilities, that applies to everybody equally. They should come forward. Those who have been guilty of abuse should be prosecuted. And there is a straight line between what we're talking about, which may be a general intrusion, the publication of a photograph, and of course the publication of sexualised images of children, which the full weight of the criminal law needs to rightly come down on.
Surely the examples that the Noble Lord the Minister gave are very different ones. If there is a general crowd scene and an individual child is not identified by name, that is distinct from circumstances where a child is identifiable and where consent has not been given. Under what circumstances does the public interest require that a child's face be not pixelated? And why Why is there any case at all in terms of journalistic integrity or freedom of investigative journalism that requires a child's face, an identifiable child's face, to be published without consent?
Lord puts his finger on the absolute point, which is the difference between images, which is the context of the campaign, as I understand it, and the identification attached to an image of a child requiring consent. That is the area of balance, and that is the area of debate which we're seeking to actually square this.
Self-regulation applied to internet service providers?
Well, self-regulation, that is something that the We Protect campaign, which the Prime Minister launched and which is actually chaired very effectively by my right honourable friend Baroness Shields, announced a major breakthrough just before Christmas about internet service providers actually seeking to remove images, child abuse images, off the internet, identify them and ensure that their abusers are actually brought to justice.
My Lord, given that 3/4 of the public believe that the media should protect children by pixelating or blurring their faces, does the Minister agree that more can and should be done to protect children's privacy?
I think that, and I acknowledge the work which the Noble Baroness has done, and also her personal experience in this area, which I'm aware of, and obviously we all understand. As we understand in the case of Privacy Protect, everybody understands, certainly every parent understands, about the lengths to which we're all prepared to go to protect our children and protect our children's safety. The question is to weigh the balance between that right to privacy and also the right and privilege of free speech and the freedom of the press, which is an underscored part of our democracy.
Yet why is free speech... Well, my Lord, the Minister has said that free speech is somehow undermined by publishing an identifiable child's image. How is it undermined?
I didn't say that it was undermined with respect to the Noble Lord. What I actually said was that there was a balance in a free society between being able to produce and publish images and actually identifying those images. In other words, the human rights aspects of Article 6, which deal with the protection of privacy, and Article 8, which deals with free speech. The courts deal with that. The self-regulators deal with that. We can deal with it in a common-sense way without the need to criminalise everybody who produces an image of a child.
Lord Berkeley.